interesting because I think a lot of these financial institutions would say that they have got a strong grip on compliance, and they have had for a long time. But that compliance is in relation to regulations, the ordinary type of banking and financial regulations that they need to comply with in different jurisdictions. This type of compliance is a little bit more challenging because it's less of that paper-based check-the-box compliance. It's more about the culture of organisations. It's more about the challenges they face in specific countries. You may be aware of Transparency International, which has an index that they publish once a year, and that index gives you a ranking of different countries and perceptions of corruption. Now, this region that we're in is coloured bright red on that map. So, the greater the perception of corruption, the brighter the red, and at least perception is a yellow colour. So in Asia, we are surrounded by countries like China and Indonesia, Malaysia, India, and a lot of these countries grapple with perhaps a way that business has been done in the past that no longer works today. So in terms of the UK Bribery Act and the FCPA, the biggest issue that we're finding is the rate of enforcement that occurs in relation to companies that are established in this market. So the FCPA is enforced by the Department of Justice and the SEC if you're a listed US entity, and they really see no bounds in terms of jurisdiction, and the number of big ticket enforcement activity have happened in our corridors. Banks and financial institutions are now feeling the heat of those type of enforcements. So you've got traditional banks that are trying to increase their footprint in this region. So they're acquiring other financial businesses, or they're lending to high-risk businesses. So suddenly they're realizing that they have not only a responsibility to their shareholders to ensure that their investment is not with businesses that are going to attract risk, and therefore the value may be depleted very quickly. They're also having to worry about the acquisitions they make for their own business. The compliance risk in M&A transactions is probably where we're seeing most activity in these type of clients. So in the article we write about the fact that under the US regulations, a company can be prosecuted if they buy a business that is founded on corrupt practices, and they allow that business to continue in that same fashion. The company that has bought the business can in fact then be found liable for that continuation, and that can result in a number of instances where they're paying huge fines and penalties based on an investigation by the DOJ or SEC. They lose the value of the business because they have to stop those practices. And if your banking license in a particular jurisdiction has been obtained through improper conduct, then that can in fact strip away the entirety of that asset that you've just purchased. So now we're finding that traditional banks and financial institutions are getting the fact that they have to understand what this risk is all about. In terms of private equity funds and houses and hedge funds, that's sort of an extension of the same issue, because private equity are known to tap into the market, find those interesting businesses with potential and turn it over. Now, all the same things that I've just said about what the banks deal with, that they're worried about what they buy in terms of risk applies. But in PE houses, there's an extra element because they need to sell. And when they come to sell, if there are issues in terms of the ability for this business to prove that it's got a grasp on risk, then US buyers are not going to touch it. Or if they touch it, they're going to pay a far lower rate in terms of that asset. European companies are not going to be comfortable about buying into that type of risk. And now Chinese companies are not prepared to buy into that risk because, putting aside FCPA and the UK Bribery Act, which I've talked about in our article, the Chinese regulators are hot on this issue. And the anti-bribery and corruption laws in China are actually being enforced as much as we have seen out of the US. So now when we're talking about buying business and then selling it in the way that private equity does, they may find themselves holding on to something that is risky for themselves in terms of their own reputation and brand if they get investigated, and also something that they can't offload and make the return that their shareholders are expecting. So this is something that's keeping a lot of people awake at night. But we have found that there is a real practical approach that you can take. We're assisting clients look at this pragmatically and practically in the event that they have to put a credible picture in front of a regulator at some time in the future.